So, guys, today we will discuss online defamation. See, the defamation, if I ask that what is defamation or how you can define the defamation, so we can define it that the defamation is an intentional false communication or false statement made before the public that uh, you know injure the reputation of the person against whom that statement is made. So suppose with reference to person A, I say that A is thief, and that is before some other person, so that would be defamation. In simple words, we can understand like this. Now, the defamation is in India is actionable civil also and as well as the criminal offense also. In the Indian Penal Code, that talking about all the criminal acts, also have the provisions with respect to defamation. Section 499 define that what is defamation, and there under the section 499 it says that by any word spoken, or it is through written or visual representation or through signs. So different mode is defined there, and that definition is important for making that in India the slander and libel both are punishable. Okay, then the punishment is under section 500 of the Indian Penal Code. That is the criminal portion. Okay, in the UK the defamation is only cause or provide for civil action. It's not defamation is not a criminal offense, but in India it is the civil as well as criminal. For the civil action, if you want to take that person X has made a statement by which my reputation has been lowered down, or that is the injury of my reputation, so you can claim for the compensation, but then you have to go by the law of the tort, and accordingly you have to prove it. Okay, now whenever we talk about or whenever we think about any remedy, first we must understand that there was a right, then only we can talk about remedy. And that is in the law of the tort also. There are two maxims: injuria sine daeminum, daeminum sine injuria. Injuria sine daeminum means injury. Injury means legal injury, and legal injury means a person has the legal right, someone has violated that. Sine without damages means नुकसान. तो कोई भी ऐसा एक्ट जिससे किसी का नुकसान हो या ना हो, बट उसके लीगल राइट वायलेट होता है, सो दैट इज एक्शनेबल. एंड दैट वी हैव सीन इन Bhim Singh versus Jammu and Kashmir, where the person was not allowed to cast the vote, but the court has awarded the compensation, the damages by way of compensation, and that was exemplary, because in the law of the tort the damages are unliquidated damages, that are not predetermined damages, unlike the law of the contract. And here in the defamation, what is the right? The right is that every person has the right to reputation. Okay, we all have the right to reputation, and if other person violate this right to reputation, how he will violate this right to reputation? If he is telling the truth, that would not amount to that he is violating the right. And that's why when I define this word defamation, that any false communication. Why I use false communication? Because when you are telling the truth, you are saying what is actually there, so that person cannot claim that you have lowered down his reputation, you has damages, you have injured his reputation. Okay, so that right we have. And by any false communication, by any statement of the person, the image, the reputation of that person is lowered down in the right thinking people, is known as defamation. So different people define, or different jurists you will find that define differently, but in the simple way or in the conclusive way we can define that the defamation is an act of making false communication in reference to a person that lowers down the reputation of that person in the eyes of right thinking people. Okay, now come to the ingredients or the essential elements of the defamation as a civil action. Okay, and then we understand that what is online defamation. The ingredients, the first one is about the publication. Okay, and this thing you will find that also important for the criminal defamation also. The first line of the section 499 that talked about that any word spoken, sign, etc. So all these things is talking about that, communication of the statement. So this publication of the statement is the first the ingredient. Publication means making that thing, making your statement, making your communication available before the public. And the public means other than that person, not only that person but other than that person. Okay, then the second is that there must be, this publication of the statement must be with reference to some person. Okay, or in case of the plaintiff, when want to take the action with respect to the plaintiff, so the statement with reference to the plaintiff. If there is the defamation with respect to person X, only X can take the action, only X can go to the court and the demand damages by way of compensation. Okay, so the first is the publication of the statement. The second ingredient is that the statement must be with reference to the plaintiff or with reference to the person whose reputation has been lowered down, whose reputation has been injured. Okay, the third is, as I said, that the publication, when I have defined that publication means making that statement available before the public, and public is or you can understand public means other than the speaker and the listener, other than that person. If you made a statement before the person to whom you have injured the reputation, that you are a thief, so you cannot say this is the communication by A to the B, but you cannot say that it is the publication because this thing was not available for the public. So this communication must be, or this statement must be reached to the some other person or has listened by the some other person. So the third ingredient or the third element I just draw from the first one, that the communication of the disputed statement or the communication of the defamatory statement must be to any person other than the plaintiff. It may be to one person, two person, or whatever. Okay, then the fourth one is that suppose, and this is just very you can say logical, that suppose you made a statement before X in regard to the Y. Okay, and this statement never came in the knowledge of Y. So there is no possibility that Y will take action because X cannot take action because it was not defamatory against X. So the finally this statement that you have made against the plaintiff must reach to the plaintiff. He must have that any that knowledge of that statement, either as the evidence also it is necessary, either as an suppose you have made a communication against particular person X, और उसके खिलाफ आपने पैम्पलेट छपवा दिए, ओके, सारे दुनिया में हल्ला होगा, फाइनली दैट पैम्पलेट एक पैम्पलेट उस बंदे के हाथ में भी लग गया, एंड व्हेन दिस कम्युनिकेशन रीचेस टू हिम रीचेस टू द प्लेंटिफ, देन ही come to know, अच्छा ये बात हो रखी है मेरे पीछे से, and so this is the fourth element, that statement must reach to the plaintiff. Fifth one the fifth ingredient is about the damages. Now how the damages you can say or damages you will determine. So here it's not necessary that there would be always the actual damage. In some cases maybe the actual damage, that because of that statement some person reputation has been lower down, and then he suffered some damage like he lost the contract or etc. And sometime it may be the presumed damage. Okay, so the fifth is the statement causes actual or the presumed damage. So these 5 ingredients has to be proved on behalf of the plaintiff. Then for the in the civil suit, definitely the burden of proof is not as strict as under the section 499. In the section 499, because there is the criminal defamation, you will find intended to, the statement intended to injure. So intention is there, very important. Here there is no need of proving the intention. Only these 5 things we have to prove for the the damages. Now the question is that what is online defamation? This is the general defamation, the traditional defamation, for that a person for damages by way of compensation can go to the court. Online defamation is, in case of online defamation, all element will remain same except the publication portion that we talk about. The publication, the communication portion we will talk about. That publication or the communication will be through the electronic medium. Okay, then that type of the defamation we will call as the online defamation. And the electronic medium means through any use of the computer. So suppose you text a message through the WhatsApp, you send the message through the Facebook, you send the message on the Twitter, you written something, or in the Facebook you have written something, or by any platform, any medium, through the email etc. By any type of the the electronic medium you have made a statement against the person, and that statement was not true, that statement was false, and that statement was to the person other than the person in reference to whom you have made, and it caused actual or the presumed damages, then one will be will be treated that he made the online defamation. Okay, now here one thing is very important, that with respect to the the online defamation, where we have to go. Earlier we have discussed that for section 43 or for section 43 capital A, we need not to go before the civil court for taking the action. Adjudicating of officer has been appointed under the section 46, and before whom we have to made a complaint. Okay, now here the only purpose of including this definition before IT Act, or the very purpose of discussion of online defamation before IT Act, is that in the communication there would be some technicality. In the communication there would be anonymity, that is, a person has gone to the cyber cafe, he created a fake email ID, and by that email ID he published or he made the statement. He created a Facebook account, and by that he wrote a defamatory post against the person. So these things are intrigued, and that's why we are discussing under the IT law. But that does not mean we are discussing under the IT law section 46 would be applicable. When you read section 46 subsection 1, it talk about that any contravention that is made under that act or rule, regulation, penalty, etc., whatever there is, for that only the adjudicating officer have the jurisdiction, that limited jurisdiction. Okay. And so for online defamation also, the same way, like other defamation where the communication is either through the words or through the written statement published in the newspaper, magazine, जो भी आपका पत्रिका वगैरह, जो भी पैम्पलेट वगैरह छपवा के, the same thing. Okay. Now if you see in your screen, there is one case mentioned here, and this case is has not been provided, but you can find here, because citation is also given, otherwise also by the name you can find it. Name of the case is SMS Pneumatic India Private Limited versus Jogesh Kwatra, suit number 1201 just 1201 2001, and it was Delhi District Court decided on February 12 2014. Okay. What happened in this case, that you have to understand, and then you have to decide this case also. In this case, Mr. Jogesh Kwatra, who was the employee of this particular company, SMS Pneumatic, so what he did, that he wrote the defamatory email against the company and the managing director, and then he sent that email to the all the employees of that particular company. Okay. And he was doing this not once, but 2-3 times, or you can say more than one. And then the company or its employees, they were come to know about this thing. The company has this type of the reputations has been he lost, or the employees were talking about the activities of the managing director, and so they wanted to take the action. So they finally filed the suit as per their compensation before the district court. Sorry. Because the civil court have the jurisdiction, so the CPC will be applicable. And in the CPC section 19, if you talk about, in case of section 19 that talk about jurisdiction, that when a suit is for the compensation of wrong done to the person or the movable property, then the place where the wrong was done will be the jurisdiction, and the place where the accused is residing, or where he is doing business, or who is work for the gain, all these things will be the places where the the plaintiff at the option can file the the case. Here, because the company was situated in Delhi, and the cause of action arises here, so they filed by using the section 19 in the district court. Here the case is visible in your screen. SMS Pneumatic India Private Limited versus Sri Jogesh Kwatra. Now here in the para number 2, you can find out the facts of this case, that talk about that the company, the SMS Pneumatic, and its managing director, both has the plaintiff 1 and plaintiff 2 have the history of business, and they filed this the suit where they are saying that during the last 1 year from the date of filing of the plaintiff has been receiving various email through the various email addresses have perpetually been sent by the same person. The chronological list of the email sent by plaintiff number plaintiff to the plaintiff number 2 on the different date as per annexure. And so they have given the all the details when the mail was sent, etc. And then on this plaint the written statement has been filed against the person Mr. Jogesh Kwatra. He has denied that he has not sent the email, and so the main question became here to actually proving that the this publication of this statement is by the plaintiff. And because they are through the different email addresses, they finally the IP address was also traced of the some cyber cafe, but there also some the discrepancy, and by which the identity of the person has not been established. Plaintiff has asking for the permanent injunction, that injunction should be passed against this person so that in the future he will not send this type of the defamatory emails or this type of the defamatory statement that injuring, causing the the presumed damages to the company as well as the managing director. The evidences were adduced by the plaintiff side, but there is some discrepancy, and by that discrepancy it has not been established that these communication, the publication was made by the plaintiff. And here you will find those discrepancy in the para number, just para number 10 onward. Onus of proving this issue was on the plaintiff 1 and 2, who examined many witnesses to prove the existence of cause of action. As far as the legal right of the person is concerned, it cannot be depend upon the status of person, especially when no damage are claimed. Status of the person in a suit or defamation will determine the quantum of the damage. So they are saying that the plaintiff 2 is the very at very high position in the company, the managing director, etc. Court is saying that whatever status you are saying and all these things, that would be important when we will define that what amount of the compensation would be given. The first question is that whether offense wrong has been committed or not, the rights has been violated or not. And for that they are saying, as far as the existence of legal right is concerned, it is available to one and all to live the life of a honorable person, and no other person, irrespective of his relation or otherwise, has right to defame other, either by raising allegations which are slanderous or defamatory per se before the fact relating to the cause of action pertaining to defame are enumerated. It is required that the defamatory facts allegation be circulated and brought to the public domain. It is the remedy against the defamation in public by circulation either through electronic media, print media, or other printed material or otherwise. Whatever material has been placed on the record by the plaintiff through the witnesses or the email, and there is no dispute about it, of various date, of which only one attempt was made by the plaintiff to trace through the private computer expert, which accounting to the report of the private expert, the email could be connected to a cyber cafe in which the identity of the cyber cafe was used by sending the email and not the person sending the email. Somehow they are trying to say that one attendant of cyber cafe, Mr. Rajiv Pandey, identified the defendant. Defendant means Jogesh Kwatra, against whom there was the allegation of the wrong committed of to defaming the company and the managing director by sending different email from a group of the photograph of some local function, that is the picnic in this case, and that was the plaintiff, but obviously admittedly that photograph has not been placed on the record. Another discrepancy pointed out by the counsel defendant is that as per the report, the entry which is purported to have been inquired into pertain to the entry of 8:25 a.m. So many discrepancy has been found by the court, and with that discrepancy, because anonymity is always the concept that baffled the investigating authorities and always work in the favor of the accused. Okay, so finally with that we have to come at the conclusion. The relief in view of the above discussion on the para number 16, keeping in the view the fact and the circumstances of the case, the suit of the plaintiff is dismissed. No order to cost decree sheet be prepared. So suit is dismissed. When suit is dismissed, when you pursue a suit, the order will be like it is decree, that means the suit is in the favor of plaintiff. If it is dismissed, that means it is against the plaintiff. Plaintiff has not proved his cause of action, or has not proved has not actually you say कि उन्होंने burden of proof नहीं proper किया. Okay, so here in this case we found that for an online defamation, along with those 5 elements of like proving the defamatory statement, then say defamatory statement means the statement is such that it lower down the image, the statement is communicated to other person, the statement make reference to the plaintiff, the publication of the statement, etc. With that, the anonymity is very important, that the statement must be published by the defendant, and that is very, very important. In the cyber offenses you will find that there is the anonymity. What is anonymity? That through our investigation we can find out the IP address from where the communication is written, because when we create an email account, no ID proof is required. When you create Facebook account, no ID is required. And so whatever the through the name, when one get the email, or one create any the Facebook account, Instagram account, that is not on the authentic identity, and so that does not disclose the real identity of the person. For finding the real wrongdoer, one has to be very clear that that must establish that it was done by that person, and this benefit was actually got in this case Mr. Jogesh Kwatra, and finally the court has not passes the compensation. So this is the end of this case, SMS Pneumatic India Private Limited versus Sri Jogesh Kwatra.